Let in our attendees. If you are listening to this right now in the present, or you are listening to this from our YouTube library, thank you so much for attending our online presentation today. We are Southern Minnesota Regional Legal Services, or SMIRLS for short, because that is a mouthful. And we are also part of legal advocacy for older people, and we hold monthly presentations to hopefully educate folks about their legal rights. So if you are here today, welcome, welcome. This month's presentation is about providing tools to deal with debt and debt collection, and we hope to give you folks some useful information from today. And our presenter, who is going to be doing that, is one of my colleagues, Nick Morrison. He is one of our lead attorneys in Smurls' consumer unit. So on that note, I will turn it over to him. But before I do, there is just one important piece of information. We will answer questions at the end of the presentation. I'll be sure to get to them before we are done for the day. And please do not enter any personal information into the chat, any kind of social security numbers, phone numbers, addresses. If you have any specific questions to your specific situations, we do recommend that you call our hotline and intake to speak to one of our legal team and maybe open a case with us. And we will have that number for you in the presentation as well. So yeah, with all that being said, I will let Nick take it away.
Thank you, Isaiah. Again, my name is Nick Morrison. I'm a senior attorney here at Smurls, and I work in consumer. I also work in housing. A little background on me. I'm retired Air Force. Spent 21 years, retired in 1999. While I was in the service, I got a bachelor's degree and an MBA. And then when I retired, I went to work for American Express Financial Advisors for a couple years, trading stocks, bonds, mutual funds, options, all those fun things. And then went to law school. And I graduated law school in 2004, went right into private practice. My private practice included not only consumer law, but also dealt with family law, criminal law, a few other areas, some civil law stuff. And then in 2021, I started with Smurls. I've been working with Smurls ever since. A little bit about Smurls. We're the oldest regional legal services organization in Minnesota. We've been around since 1909. We operate in 33 southern counties. Basically, if you drew a line from St. Paul down through Scott and Carver and then straight out to Worthington and then went east to that line all the way around to the Wisconsin border, that's pretty much where our area is at. We have offices in the metro area, and in addition to that, Albert Lee, Rochester, Winona, Worthington, and Mankato. Some of the areas that we practice in, Smurls as a whole, we have family law, housing, economic justice, immigration, elder law, education law. We work with migrant workers, and we have consumer law. Our eligibility is reasonable. We have up to 200% of the federal poverty guidelines, and then there's some exemptions for equity in your house, motor vehicle, personal property to include cash on hand. If it's a bigger household, more than one, that doubles to 6,000. If you're over 60 years of age, you're considered a senior, and there is no income or asset restriction. So a lot of my work that I do, I'd say probably half is dealing with seniors that are having problems with collection agencies, and we take those cases on pretty readily. So today we're going to talk about collections. Then we'll go a little bit into lawsuits. We'll talk about garnishment and the difference between garnishment and levy. I'll touch on identity theft. And finally, we'll talk a little bit about bankruptcy. So collections, how do they collect? Well, they start out by making phone calls. If for some reason you haven't made your payments, life happens, all kinds of things happen, medical problems, etc. You're not making your payments. Initially, you'll start getting phone calls from the owner of the debt, Capital One or Discover or J.C. Penney's or Chase or whoever it is. They'll start calling and saying, "Hey, you're going to make your payment." They'll probably send letters out too. After about 6 months, they normally charge off those particular debts, and that's when the next level of collection starts. Okay, you'll get a collection or what's known as a demand letter or a debt validation letter from either a collection agency. Some of those would be J.C. Christensen. Can't think of any of the other ones off the top of my head, but there are several that are collection agencies that actually aren't buying the debt. What they're doing is they're collecting on behalf of the owner. They're collecting on behalf of Capital One, or they're collecting on behalf of some of the other credit cards that are out there, or some of the other loans. Um, uh, they'll send out a demand letter, or otherwise known as a debt validation letter. And then if you don't make any payments on it or try to make some type of an arrangement, they'll eventually start a court action and a lawsuit. I'll go into a little bit detail for each one of these things. So now phone calls. Well, if it's a collection agency or it's a debt buyer, they can only call you once a day. There's a caveat to that. Excuse me. It's once a day if they actually talk to you or leave a message. Okay, because normally they call on a blocked line, so you're not actually going to know who it is. So you could come home, see that you got 10 phone calls, or you can look and see that on your cell phone that you've got, some 10 phone calls, all of them blocked numbers. If you've never answered it, it could be the same one. They're not supposed to call you more than once per day, but if you can't prove that it's them that's been calling you over and over again because you can't see the phone number and they never left a message or actually talked to you, then they will call you more than once a day. Once they actually leave a message or actually talk to you, they can't call again that same day. They can call again the next day. But if they call more than once in a day and actually identify themselves, then they can get into a lot of trouble. They're violating the collection laws. They can't threaten something they cannot do. Only the debt owners can actually sue you. So if it's Capital One or if it's Discover or if it's one of those and they're the ones that are calling you, yes, they can say that they're going to sue you and garnish your wages. But if it's just a collection agency, unless they've actually become a debt buyer and bought the debt from the original owner, they can't threaten to sue. They can't threaten to take your house. They can't threaten to take your car. They can threaten to garnish your wages up to 25%, but they can't threaten the things that I just talked about, because much of the things that I just talked about, your house, your car, your personal belongings, other than money, are exempt. And there's a statute in Minnesota that exempts that stuff out. So they can't just arbitrarily threaten to take your house. I've actually dealt with some debt buyers out there that have tried to threaten to do that, and I get on the phone and remind them that that's an FDCPA violation, and they climb up pretty quick. Now, you can stop them from calling you with a cease letter. A cease letter is something that has to be in writing in order to cease the calling. When I say writing, that's a letter. It cannot be an email. Also, if you have them on the phone, you can't tell them, stop calling me, I'm not going to pay you. They can ignore that. They can ignore the email. But if you send an actual letter that ceases them from calling, that says, stop calling, I'm no longer going to allow you to contact me, that they have to abide by. If you're going to write this type of letter, and I'll show you an example of one here in a minute, you send it by mail that can be tracked. I always tell people to do that via certified mail. That's the cheapest way to send trackable mail with a tracking number. But you can send it, overnight mail. You can send it priority mail. You can send it via FedEx. You can send it via UPS. But send it some way that it can be tracked with a tracking number, and then you can download the verification of the delivery. Now, this is extremely important because later on down the road, if they continue to call you after you know that that the letter's been delivered, then you can contact us at Smurls, and then we can go after the debt buyer or collector for violating the Fair Debt Collections Practices Act, which is the federal collection law. You always want to keep a copy of the letter as well, and that's very important because I want to be able to see what you sent them, and put that with a copy of the verification of delivery, and then I send that to them and say, you just violated the FDCPA because you're continuing to call, and you keep a record of the additional phone calls. So I know you received the letter on day one, and you called on day two, day three, day four. You continue to call even though that letter was delivered. Now you're in violation of the FDCPA. This is an example of what the collection or the cease letter looks like. And it's pretty simple. I'm sending you this letter in response to a demand for payment or a debt validation. This letter is a notice sent pursuant to the Fair Debt Collections Practices Act that you're no longer permitted to contact me. Cease all telephone communications. Don't call my residence, place of employment, or any other phone number associated with my name. So once they receive that, they're not allowed to continue to call unless they're calling to notify you that they're pushing forward with a lawsuit. That they can do, but they're not allowed to continue to call you after that and try to collect on the debt. They can notify you of court action, but that's the only thing that they can do. Demand letter, or otherwise known as a debt validation letter. Whenever a new collector takes over a debt, or in most cases, a debt buyer is somebody who actually buys the debt from the company that originally owned it. Debt buyers, to give you an example, would be LVNV Funding, Midland Credit Management, Portfolio Recovery, Calvary, SVS. These are all debt buyers. They actually buy the debt for pennies on the dollar, and then they try to collect on them. So whenever that happens, they send out a debt validation letter and it advises that this collector now owns the debt. It'll state that you have 30 days to dispute the debt, and it normally gives a deadline date. It's usually up on our upper right-hand side. It says you have to dispute it by this date. If you don't, the debt becomes valid. It states the amount that you owe. And this particular letter looks very similar to a regular bill statement. It has the amount of interest. It has the amount that was originally owed. It has the date as a due date that is the 30-day date to dispute the debt. It has the addresses on it to where you want to write in writing to dispute the debt. And it looks a lot like a regular statement. You need to keep a copy of this letter. It's very important because the letter has certain rules that it has to comply with. And if it doesn't, then once again, it's a violation of the Fair Debt Collections Practices Act. And I want to just kind of mention here, okay, they violate the FDCPA. What happens? Well, there's a couple things. They can be sued, and they can be sued both in state and federal court. The damages, anything that you're out, if you've had to pay for an attorney or if you've had to drive somewhere to argue this, anything that's involved with the violation of the FDCPA, you can get reimbursed for that. Plus, there's a sanction of $1,000. It's not any more than that. And you might think, well, why would it be worth it to them to even think about it? If they get sued in federal court, where it hurts them the hardest is the attorney's fees, because what happens is that once it gets into federal court and it starts being argued, attorney fees could end up being $20,000-$30,000 or more. So that is the bargaining chip that gets them to at least somewhat comply with the FDCPA. If you're disputing the debt in accordance with the demand letter, you have to do it in writing. You can't call them up on the phone. You can't send them an email. You have to do it in writing. There'll be instructions on the demand letter. You want to follow the instructions exactly how they're written. Again, and any time you're dealing with any type of a collector, you want to send it out in trackable mail, and you want verification of delivery. Okay. Many times these collection agencies will deny that they ever received it and then proceed on. If you don't have proof that they received it, then they get away with it. Must be within 30 days of the date of the letter. And like I said, most of those validation letters have an actual date on them that says by this date, you have to have the dispute in writing. Once you do that, and you do that within the 30 days, the debt collector must stop all collection activity and provide you with verification of the debt. That verification can be anything from your original application for the debt, any receipts that may be for purchases that may have come, uh, how they obtained the ownership of the debt. There's many different documents that they have to provide you, and that validates that's in an effort to validate that they own the debt and the debt is a valid debt that you owe. If you're not disputing the debt, ignore the letter, but make sure you keep a copy of it. Again, if later on down the road they do something that violates the FDCPA, I'm going to want to see a copy of the letter just in case they violated the rules on how the letter is supposed to be taken care of as well. All right, so what happens next? Okay, so you get the debt validation letter, and the 30 days goes by, and you haven't called them, and you haven't sent a dispute letter. You don't have the money to pay. What happens next? Well, eventually, the debt buyer or the owner of the debt, one or the other, will sue you, and there's two different ways they can do that. The first one is in district court. You'll get a summons and complaint. The sheriff or a process server will show up on your doorstep, knock on the door, and when you answer the door, or anybody that's of 18 years of age or older and doesn't have to live there, if they answer the door, they can hand the summons and complaint to the individual and walk away. That's considered proper service. It does not have to be a family member. It doesn't have to be you. It doesn't have to be, it could be your neighbor. If they see them and they hand it to them, it's considered valid service. There'll be no case number on the front of it. This is one of the few states, Minnesota is, that they do what's known as pocket filing. Pocket filing is that they serve it first and then file it with the court. So when they serve it, there's no case number on it. This really confuses people a lot. And in many cases, they look at it and go, this isn't a valid court document, and they throw it away and ignore it. Don't do that. In Minnesota, it is a valid document. They will file an affidavit of service that they sent it. When they file the document with the court, and this is part of the game where they want you to think that it's not valid, that you ignore it. And then what they do is they'll file that. They'll file a copy of the summons and complaint. They'll file an affidavit of service, and then they'll also file an affidavit of default if you didn't answer within the appropriate time. So if you get something like this, even if it doesn't have a case number, but it's from district court, it's most likely a valid document. If you're going to dispute the letter, the lawsuit, you must file an answer with the court and served upon the other side within 21 days of service. If you don't do that, you will be in default. So I've had instances where when people have been served something and I don't get it until well after 21 days, but it's before the default hearing, where I filed a certificate of representation, and the court then resets the default hearing and cancels it. But if you're going to dispute it, you must file an answer within 21 days. It's important that you do that. Otherwise, you'll be held in default, in which case you won't get a chance to argue your side of the argument. District court has many rules. It's very difficult to navigate without an attorney. Some attorneys have problems with navigating it, and they're supposed to know how to do it. So it's a very complicated process. If you're not going to dispute it, and I'll talk about this here in a little bit, it's probably not a good idea to file an answer, and I'll explain why here in a few minutes. But if you're going to dispute it, you have to file the answer within 21 days. The other way they can sue you is via conciliation court. Conciliation court is the people's court. For those of you that watch TV, that's Judge Judy. That's exactly what conciliation court is. You go in, you're not represented by an attorney, the other side's not represented by an attorney, and they present their side of the case, you present your side of the case, and the judge makes a decision. Instead of getting a summons and complaint, you actually get mailed what's known as a statement of the claim. And I'll show you examples of both of these in just a minute. But basically, it's about a 3 or 4 page document that says this is why you owe the money, this is the amount that you owe, and it's very informal. Whereas district court is very formal. That's where all the rules are. There's a whole lot less rules in conciliation court. It's designed to be easy for people that are not represented. You don't normally do an answer in conciliation court. You normally show up and you argue. The other side does their argument, and then the judge makes a decision, just like you see on TV. If you're disputing the debt, you must go to the court hearing to argue. If you're not there, you'll be considered to be in default. The judgment will be awarded to the other side, and now you'll have a judgment, and it'll be very difficult to undo that judgment, even if you have a valid argument to dispute, because you have to explain to the court if you didn't have, why you missed it, and if you didn't have a valid reason for missing it, the court most likely won't undo the judgment. Court rules are somewhat relaxed. No attorneys needed. In many cases, if it's a person suing another person, or something like a landlord that's suing an old tenant, they don't allow attorneys in. If an attorney is on the other side representing a business, then the court will normally allow an attorney to represent the individual that is the defendant. A little bit of statistics here. 82% of all civil court proceedings in district court and 54% of all court proceedings in conciliation court are collection lawsuits. This is what takes up the majority of time in the two different court arenas. What you're looking at here, the document on the left is basically the summons. There's more to it than that, but it goes in, it talks about you're being sued, you have to reply in writing, it talks about what the answer is, it's very formal. On the right is the complaint. It talks about what you're being sued for. In this case, it's JC Systems is the collector. They're collecting for One Main Financial. Tells you how much and what they're asking for, etc. This is a statement of the claim. It's a little bit different. It basically says, this is the amount you owe. They want you to pay the filing fee, which is usually between $70 and $85. And it has a brief narrative explaining why you owe the money. Much more informal. It can be handwritten. If it's coming from a collector, it's normally typed out like this. But if it was from another individual, a lot of times they're just handwritten. So the question is, should you answer the district court complaint or not? Yes or no? Well, if you're disputing the entire debt, you should answer. And when I say the entire debt, okay, so you charged $1,500 on a Capital One card, and now the bill is $3,200. Well, I don't know $3,200. I only charged $1,500. The problem is that they've tacked on fees. They've tacked on court fees. They've tacked on lawyer fees. They've tacked on interest. They've tacked on, all the different types of costs. So if you're not disputing the entire debt and try to dispute just the extra fees, that you will not be successful. If you come back and you have a defense and say that you're disputing the entire debt, I don't know where this came from. I don't know what the original 1,500 was for. I don't agree with any part of this. Then you're going to want to file an answer. If you're not disputing the entire debt, and this is what I mentioned before, you don't necessarily want to file an answer because it will increase the amount owed. If you're in district court, you file an answer, you actually start the court process. So the next thing that's going to happen is there's going to be discovery. The other attorney on the other side is going to have to draft more documents. Those documents will cost money, and that will increase the amount that's owed. So if you don't have a defense, and I'll talk about some of those here in a minute, and you're not disputing the entire debt, you're well within your right to file an answer, but it's suggested that you don't. let them get the default judgment and keep the cost down to the minimum amount. Conciliation court. This is a little different. Should you go attend the conciliation court hearing? I want to back up here just a second. If you're in district court and you don't file an answer, the judge most likely will not let you talk in court. That is not the case with conciliation court. Conciliation court, each side gets their own time in order to be able to put on their case. So if you want to go and you want to try to plead your case, even if you don't have a defense, you're not going to get charged anything extra like you would if you filed an answer in district court by going to conciliation court and just talking to the judge. If you're going to dispute, you need to dispute the entire debt. You're not going to dispute half the debt by saying, this other half is not mine. If you're not disputing the debt, the judgment is inevitable. There's no need to argue. That goes with district court as well. So it's up to you. You can go. You can talk to the judge. There's mediators that are often involved with conciliation court. You might be able to mediate the amount down, or work with them, set up a payment plan, avoid a judgment. So I usually tell people to attend the conciliation court hearing because you may be able to work something out in your favor. So, okay, they get a judgment. What is a judgment? Okay, well, it allows them to, at that point, you've got a court order that says that you owe a certain amount of money, and then once they obtain that, well, they can garnish your wages if you're working. They can levy your bank account. What that means is that they can freeze it, and they can take up to the amount of what's owed. So if you owe a couple $1,000s and you happen to have that in your checking account and they find out where your checking account is, they can hit the account for the entire amount with the fees and everything else. And if you don't have a defense, like being on public assistance or something of that nature, they're going to keep it and you're going to be out the money. They can if they get a judgment, it puts a lien on any real property that you have. However, the judgment has to be filed in the county where the real property is. So if you live in Washington County, for example, or Olmsted County, and they sue you in Olmsted County, and they get a judgment in Olmsted County, then any real property that you have, any house or land or anything, that judgment automatically attaches to the real property title. If you own property in Washington County and it's sued in Olmsted County, they would have to physically file the judgment again, not another court hearing, but just file the judgment in Washington County, and then it would attach to any property you had in Washington County. If they don't know you have it, or they don't actually physically file the judgment in Washington County, then it wouldn't attach. So what kind of defenses can you have for a lawsuit? Of course, debt. I'm going to get into that in just a few minutes. Identity theft. We're going to talk about that as well. You filed bankruptcy, it was discharged in a bankruptcy, and now they're trying to collect. I actually had one of these about a year and a half ago. Actually, I'm sorry, a year and a half ago with a debt collector, and then just within the last few months with a personal debt that somebody sued, and it was discharged in bankruptcy, and they tried to collect on it anyway. All right, so they get a garnishment or a levy. Garnishment. Okay, they can garnish or take up to 25% of disposable income. Disposable income is considered the income after taxes. Okay, it's not that includes any income that may be going out towards child support or to spousal maintenance. It's strictly after taxes. So they can take up to 25%. It depends on how much you make. If you make 125% or more of the poverty level, the federal poverty guidelines, they take 25%. If it's less than 125%, then it goes down by 5% increments down to a minimum of 10%, depending on what you're making. Bank levy. If you're not exempt, like I said, they can take up to what's owed. They contact the bank, and the bank freezes the account. The difference here is this: garnishment is done where they notify the employer takes it off the top. You have you get a notice of intent to garnish. You have an opportunity to provide exemption forms if you're on public assistance, and, and they have to stop before they even start. With a bank levy, they take the money first and then give you 15 days to explain why they can't keep it. And then what happens is in most cases, the bank will then in turn uh, hit you with some type of a fee. Sometimes it's pretty expensive for the fact that you got a bank levy, even if they shouldn't have levied your account in the first place. So that's unfortunate as well. The notice of intent to garnish, they're supposed to send you one along with the garnishment form. That's basically just that. We're going to give you 10 days, and in 10 days, we're going to garnish your wages. The exemption form talks about, and I'll show you an example here in a minute. The exemption form talks about all the different things that if you're on public assistance, or you're on Social Security, or you're on disability, or various different things are exempt income. They can't garnish that. If you're not on public assistance, you're just working, whatever, there's not a lot you can do in order to stop the garnishment. But they have to send a notice of intent, and they have to give you 10 days in order to try to execute the exemption form and get it back to them to stop it before they start. As I mentioned, exemptions such as Social Security, or if you're on public assistance. If you're on public assistance, they're not allowed to garnish any wages whatsoever. When do you call us? Well, anytime you're on any one of the two things and you get a bank levy and they've taken your Social Security, you're on public assistance and they're garnishing you, even if you don't understand how to fill out the exemption form, you want to call Smurls. I help people fill out exemption forms all the time. I have points of contact in the major law firms that do the collection, that do the collection actions. So a lot of times what happens is that I get a representation agreement, have the client fill out an exemption form and sign it. Once we do that, I send it off to my point of contact, and it stops it right then and there. I don't have to take them to court. I don't have to do anything above and beyond. I can get it done pretty quick. The exemption form must be received by the collector within 10 days of the date that the notice of intent is dated. One of the games that they play, though, however, is that they'll date it on a specific day and they won't mail it out for 5 days. And you'll get the exemption form and the notice of intent 2 days before they're actually going to start the garnishment. Happens all the time. They come back and they say, well, we can't control it. It takes a week or 10 days for the debtor to get a copy of the garnishment notice. You want to obtain documentation of public assistance from the county. The reason for this is that if you obtain the documentation that you're receiving public assistance from the county versus them doing it, they can garnish first and continue to garnish and take a month to obtain the proof, and then they'll give you the money back. But in the meantime, you could be out the money. If you obtain the documentation of public assistance from the county first, and I send that in with the exemption form, there's no argument. They have to stop it right then and there. They have proof of it. And the rule is that you either have to be on public assistance or have received public assistance within the previous 180 days. And if either one of these is true, then they cannot garnish your wages. Again, anytime you deal with them, you want to send it out by tracked mail, whether it's overnight mail, certified mail, UPS, FedEx, and you always want to make sure that you download and obtain the delivery verification. This is the first 2 pages of the 4-page document that's an exemption form. If you look over on the left, these are all the different things of public assistance that you can be receiving and have your wages be exempt. So you can see MFIP, general assistance, emergency assistance, medical assistance, emergency general assistance, supplemental aid, food stamps, Medicare Part B premium payments. Any of these things are considered to be exempt. And then you get over here, and what you're going to want to do is you have to put in right in here the case number in the county. But like I said, you always want to attach a copy of verification of benefits from the county to prove that you're actually still receiving it. Social Security is exempt, unemployment's exempt, workers' comp is exempt, and any of your VA benefits, veterans benefits, veterans pension, veterans disability, any of that is also exempt. Accident, disability, or retirement pensions are also exempt. 401ks are exempt up to a ridiculous amount of money. Payments from life insurance policies, earnings of a child under 18, child support, but not spousal maintenance. Spousal maintenance is not exempt. Death benefits paid, in other words, any type of life insurance payment, that's all exempt. They can't take it. Another thing that's important here is one of those things that says money paid to me from a claim of damage or destruction of property. This means, for example, if you get in a car accident and you obtain money from the insurance company to get your car fixed, they can't take that either. That's exempt. Identity theft. What is identity theft? And some of the examples of identity theft, they get a hold of your social security number, they apply for a credit card, they apply for a loan, car loan, mortgage, they can apply for all kinds of things. So how do you defend against that? Well, the first thing you'd have to do, again, and you're going to see this question pop up in just a minute, when do you call Smurls? If you've got an identity theft situation, you're going to want to call us right away, because there's certain things that you have to do to stop it. First of all, you need to do an affidavit of identity theft. And normally when you find out that you're a victim of identity theft is when something's in collections and you start getting calls or you start getting letters to collect on a debt that you have no idea what this debt is. So, or you may have a judgment against you, and that all the court documents, because they were in conciliation court, were mailed to some fictitious address. And in the meantime, they've gone through, they've got a default judgment against you, and they've had your social security number, and now you've got this debt and you don't know anything about it. So you're going to file an affidavit of identity theft. This is a several page document that I normally hand to my clients and have them fill it out. Then with that, you have to file a police report, and you need to make sure that you obtain a copy, because you're going to need to have the copy with the affidavit of identity theft, and you're going to need a copy of the police report for this, to file an FTC report. That's the Federal Trade Commission. You go to identitytheft.gov and you fill out the report. They're going to want to know the name of the officer, the badge number, the police department. So you got to have the copy of the police report right there with you. One of the things that's important here, if you don't remember anything else, about halfway through, it's going to ask you, do you want to print a copy? You have to say yes. Then it will not give you an opportunity to go back and and print it later on if you say no. If you don't have a printed copy, then you would have to go back and file another report. You take all three of these things and you give it to the debt collector. Okay. I collect that, I give it to the debt collector, and then if it's an actual judgment, I would file a motion to have the judgment set aside. The longer the judgment's been in play, the less chance I have of getting the judgment set aside. So as soon as you find out about a judgment against you or some type of collection on a debt, you need to call us right away. Coerced debt is the use of a debtor's personal information without their consent. A lot of times this is through threats of force or violence. to make the victim obtain a credit. Use of intimidation, fraud, coercion, economic abuse to obtain credit in the victim's name. So what are some of the protections? This just came into play a couple years ago. 332.71 through 332.75 protects victims of domestic abuse, sex trafficking, and labor trafficking who owe coerced debt. You got to have documentation. Documentation is extremely important. That's going to be police reports. That's going to be, domestic violence reports, identity theft report. You got to fill that out. That means that you got to do the Federal Trade Commission. You have to do the police report for the identity theft. And then what happens is you go into court, represented by an attorney is always better. And then the court will basically issue an injunction against the collection agency and say that this debt is considered coerced debt and therefore cannot be collected upon and needs to be dismissed. You petition the court for a declaration, as I said, that it was coerced, which can result in an injunction. A key point here is that at no time could the debtor have used the credit card or the credit that was obtained for their own use. Many times people call in and say it's coerced debt. And then when I look into it, I realize that they used the credit card themselves, and then the person went and used it after that. Unfortunately, there's no way that the debt collector can figure out what is considered coerced and what's not if you're using the card yourself. This is only good if the debt has been obtained and the abuser is the one that's using the debt or the credit for their own behalf. Right. So the last thing we're going to talk about is bankruptcy. Okay. There's a couple of different ways of filing bankruptcy. There's Chapter 7, which is a full liquidation. Chapter 13, which is a reorganization. And then there's different exemptions. There's federal exemptions, and then there's state exemptions. I'll go into this a little bit more to explain why one or the other, and which one you would pick. And when do you call Volunteer Lawyer Services, Volunteer Lawyers Network versus SMERLS? Volunteer Lawyers Network is the only other agency that I'm aware of, legal aid agency that does bankruptcies. So for a Chapter 7, this is a full liquidation. You fill out the documents, you do all of the things that you're supposed to do. You have a hearing within 30 days of filing, and then a total of about 90 days from the date of filing, you get a discharge. That wipes everything out. You don't have to pay anything more on the particular debts that were listed, and even in most cases, debts that weren't listed moving forward. It discharges most debts. It will not discharge. There is a whole list of exemptions of debts that won't be discharged. Wrongful death, restitution, court-ordered restitution, student loans. Most student loans will not get discharged in a bankruptcy, although there is a way to discharge some student loans. But it will discharge most debts. No monthly payments to a trustee. And it's not good when you're behind on a house or a car. The reason being is that if you're behind on your car or behind on your house, you have to cure the debt or the arrearage, what you're behind, within 30 days of filing. If you don't do that, what happens is that the creditor will file for what's known as relief of the automatic stay, and when they do that protection that you have from bankruptcy on that particular item goes away. Then they can go ahead and proceed on with a repossession or foreclosure. And like I said, under some circumstances, you can discharge a student loan, but it's very, very difficult to do. And you pretty much have to be on Social Security disability in order to do it. Once you file, you cannot receive a discharge within 8 years of a previous filing. So if you file today, you can't get a discharge on a second filing within 8 years of today's filing. Chapter 13. Now, this is a reorganization. The discharge will come in 3 to 5 years. You have to develop and implement a payment plan in which you're going to be paying every month. There's also monthly payments as part of that goes to the trustee. The trustee gets a percentage of whatever you pay, and then the trustee in turn facilitates the payments to the creditors. This is the one you want to file when you're behind on a vehicle or on a house. This allows you to take the arrearage, stop a foreclosure, for example, take the arrearage, finance it over a 3 to 5 year period. You go back to paying your normal payments. You pay all of your necessary expenses, but you have to have enough disposable income on top of that in order to be able to implement a plan to pay the arrearage on the house or on the car. If you can't do that, this will not be successful. And if you really don't have, if it's not even close, the trustee will dismiss it before you even get started. This is good when you're behind on state or federal taxes, because you can work to state and federal taxes can be discharged in a bankruptcy if they are more than 3 years. If you're filing the bankruptcy more than 3 years from the date that you filed the taxes, not the date that the taxes were due, the date that the taxes were filed. So if it's more than 3 years, you can discharge normal income tax, what you owe the IRS or the state. You can discharge that in bankruptcy. If you're inside that and you owe payments to the IRS or to the state, you can finance those payments over a 3 to 5 year period, and it will stop the penalties. It will not stop the interest, but it will stop the penalties. Exemptions, federal exemptions. Federal exemptions, when you file under the federal laws, they have a very liberal wildcard exemption. The wildcard exemption is something that doesn't fall under any of the other exemptions, like for a car, or for household goods, or for your home, or whatever. It could be cash, could be a collection of baseball cards that's got value, a collection of stamps, something of that nature. The federal exemptions allow up to almost $16,000. I think it actually just went up. It's a little over $16,000, and you can put anything in there. You can put cash, you can put diamonds, you can put and exempt it out. They have very liberal exemptions for household goods, personal properties, vehicles. Basically, if you file under the federal exemptions, they really don't take anything ever. You can only have a small amount of equity in your home, though. It's up to $31,000 now in equity, and that doubles if both of you are, if you're married and both of you are on the title of the house. That goes to $62,000. But if you have more equity than that, you have to file under the state, and I'll explain why in just a minute. Okay, you can have $520,000 in equity in your home for the state exemptions. It has liberal exemptions for household goods, personal property, and vehicles. In fact, the exemptions for the state of Minnesota are higher for household goods, personal property, and vehicles than they are for the federal. The problem is that there's a small wildcard exemption. So the only time you want to file under the state exemptions is when you have more than 31 and or 62,000 in equity in your home. The wildcard exemption is only $1,500 as opposed to $16,000. So there's a lot less that you can exempt out. If you have any money in a savings account, if you have any money that's owed to you on an income tax return, a lot of this it becomes property of the estate, and you have to surrender a portion of it over to the trustee. Volunteer Lawyers Network does standard Chapter 7 bankruptcies. When I was in private practice, I used to do bankruptcies for them under Chapter 7, and it's just that. It's volunteer lawyers. The drawback is they don't do any Chapter 13 filings. That's not something that they offer. There's a very long waiting list. The last time I checked, I believe there was over 500 people waiting, and some 60 attorneys is all they have for volunteers. That may have changed. I haven't looked into it for a while, but there is a long waiting list. For us, we do filings when there's an imminent housing issue requiring a prompt filing. That is that if you're going to lose your house and you need to file a Chapter 13, I can file a 13 in order to protect your house and finance the arrearage. I also do filings for people that are homeless. And one of the reasons why they're homeless is excessive debts towards landlords. It's not going to get them out of a shelter right away, but it will help to get them back on the road to recovery by filing and wiping out the debts and moving forward. I can file a 7 or a 13 as needed, and there's no waiting list. And that pretty much concludes my presentation. So I would like to offer it up if there's any questions on anything or anything of that nature. Isaiah, do we have anything?
That was some really good stuff, Nick. Yeah, that was fantastic. And yeah, we do have one question so far, which I will read out. And yeah, if anybody else has any questions, now is certainly the time to type them in. But yeah, our first question is, what is the max you can make a year to qualify for Chapter 7?
That's an interesting question because it depends entirely upon the size of your household. There's a thing called a means test. And it's an IRS standard basically, and you can go online and you can look at what the means test is, and it goes by state and region as well. So the means test for somebody in California is higher than the means test for somebody in Minnesota. And like I said, and the more people that are in the household, the higher the amount is. So that's one of the things that gets filed. So what happens is you log in all of the pay of what you're making, and if you're below that, then you're good to go. If you're above the means test cutoff, then what happens is that you do one of two things. You either convert it to a Chapter 13, or you have to have your attorney provide an argument as to why you shouldn't be filing the Chapter 13. Um, the idea of bankruptcy is to give you a fresh start. It's not to give you a windfall. And so they guard very, very carefully against people being able to have a windfall. For example, even if you're below the means test, if you have a considerable amount of disposable income left over before you even get rid of the unsecured debt, they're going to force you to file Chapter 13. The U.S. Trustee's Office, which is in Minneapolis for the District of Minnesota, reviews every filing. And if they determine that you have too much money left over, they are going to send a nice little note to the filing attorney to saying, you need to explain to us why you're not filing a Chapter 13. So there's no real specific line in the sand, if you will. It really depends on the circumstances of the individual, as well as how many people, how many dependents, how many people are living in a household, etc.
Fantastic. All right. And yeah, there weren't any new questions while we were answering that one. I can certainly give it one more minute here to see if anybody else has any more questions. Give it one more little bit here. Yeah, if you don't have any questions, you can certainly hop off the Zoom meeting now, but we'll give it one more minute here. The person who asked the first question said, "Thank you so much." Yep, one question, yeah, might be a bit general, but yeah, one question is strategy for challenging debts.
Can we be a little bit more specific? Are you talking about some type of debt defense, or if you want to dispute a debt? Is that what they're looking at?
It was just strategy for challenging debts. Yeah, this might be one of those situations, where if they want to discuss their own specific circumstances, they may want to call the intake line.
That might be a good idea. If you're looking at to try to dispute a debt, the areas of dispute are pretty narrow. Identity theft, coerced debt, and bankruptcy are pretty much the three main ones. Outside of that, there's not really much you can defend against. If you got a judgment against you on a specific debt, and it was one that you don't feel that you owed, um, that's when you want to contact Smurls and say, hey, look, I've got a judgment against me. I don't know anything about this. I don't know anything about the debt. That was never given. I was never served on the papers for the court appearance. Then I can go in and gather everything together, talk to the law firm that tried to do it, find out, if they have an affidavit of service, was it personally served, etc. And then what happens is that if I don't get a decent answer, I can file a motion under one of the rules of civil procedure to have the motion or the judgment set aside, and then rehash out the debt, re-argue it in court, and hopefully get it dismissed.
Great, awesome. And then yeah, the next question, yeah, is hello. The city repairs my sidewalks and sent me an invoice which I cannot pay in full. They are saying it will go toward my property taxes if not paid. Is that a bad thing?
You're going to pay it one way or the other. The property tax thing, though, is this: if it increases your property taxes to a point where you can't afford your property taxes, that becomes a bad thing, because if you don't get those paid, they can take your house, and then that ends up into a whole different area. They'll take your house, then they'll try to sell it back to you on a contract for deed, and if you default, then you lose the house. And then they sell it. They have to give you anything above and beyond what they owe, but you've lost your house. So you want to try to figure out some type of a payment plan. And I know they do payment plans. I mean, I've had assessments against me. I've had relatives that have had assessments against them, and their payment plans tend to be fairly liberal. I've seen them as much as 10 years over a period of time. And what they do is it's part of your property taxes, but it's a payment plan that goes along with that. So they tack on an extra $100 or $200 or whatever it is onto your property taxes, and you pay it over a long period of time, at a low interest rate, if any interest at all.
Awesome, perfect. And yeah, we have one follow-up question, yeah, from the person who asked about strategy. They also ask, how do you determine the statute of limitations on debts when they are sold to new buyers?
The statute of limitations it's twofold. The statute of limitations is 6 years from the last time um, you paid on it. Okay. So it's 6 years from that point, unless they get a judgment. If they get a judgment's good for 10 years. But let me explain this. So this is how bad this game can be played. So at 5 years and 11 months, they can file for a judgment if they initiate by serving you in that time frame. It tolls the statute of limitations. So then they get the judgment. The judgment lasts for 10 years. As long as at least one day prior to the 10-year from the date the judgment was given, okay, they initiate a renewal of the judgment. They can actually wait up to 1 year before they actually file the renewal. So now it's at 11 years, and they can get it renewed for another 10 years. Now, I haven't seen it go past 20, but I've heard that there are some that are pushing it past 20 years. So, and trying to go for the 30-year mark. So, yeah, that's how the whole statute of limitations things work.
Excellent. All right. Yeah, perfect. Well, yeah, we are at the 5 o'clock mark, and I want to stay respectful of everyone's time. So yeah, if anybody has any more questions that they have or they may think of later, you are always welcome to call our intake line and speak to some of our attorneys over the phone if you have more questions unique to your situation. But yeah, everyone, thank you so much for your attendance. Thank you for those questions, and Nick, thank you for doing a fantastic job here today. And yeah, I will be sure to put this up on YouTube at a later date, and I'll be sure to send out folks a link when that happens. So, with that being said, yeah, I will go ahead and end the presentation. So, thank you so much, everybody, and take care.